Hello, everyone, and welcome to On Trial, the podcast where we explore how to build your practice, trial tactics, and what can make or break your case. We're your hosts. I'm John Risvold.
I'm Matt Heimlich.
And today we're going to have a special episode. We're going to talk about one of Matt's tremendous verdicts in a nursing home case. And I don't want to give away too much right off the bat, but Matt, tell us a little bit about the case. Give me the 30,000-foot view of the case, and then we'll dive into the nitty-gritty.
Yeah, well, since we're not trying cases these days, we figured this might as well reflect on trials of, times gone by and, try to figure out what can be learned and what kinds of, things there are to glean from past successes and past failures too. What you do different, what worked, what didn't work. And the reason I like this case, and one of the reasons I wanted to talk about this case today, is because, not necessarily the size of the verdict. I mean, it was a good verdict for the case. We got a $588,000 verdict for an 84-year-old female nursing home resident who had a hip fracture and then a subsequent decline afterwards. So the verdict was good for the case.
I was going to say, as an aside, let me say, to get a $588,000 verdict for somebody of that age is tremendous. And so I don't want to downplay that. I'm going to give you credit where it's definitely due. Why do you think that it's the right size verdict for the case?
Well, I thought it accurately reflected what the damages in the case were and what our proofs were. We've had guests on our case, I'm thinking Chris Norman, I'm thinking Pat Salvi, who have literally had 9-figure verdicts that they've either achieved in Pat's case, as the primary attorney, or Chris has been part of a huge team, to try a case of that size. And this is not that. And every case, has its value, and our job as attorneys is try to get full value of that case for our clients. And I thought, this is a nursing home fall case. There's a lot of those out there. I'm sure a lot of people have a nursing home fall or a hospital fall case on their docket somewhere. Not a lot of people have, 9-figure birth injury cases on their docket. Not a lot of people have, 9-figure an airport shelter collapsing on a young woman and paralyzing her for the rest of her life cases on their docket. So I thought it's a little more relatable, a little bit more universally applicable. And, not a lot of these cases actually go to trial, especially in the nursing home context in Illinois. A lot of these cases resolve, and this didn't for various reasons. So I got to, try a couple things. I got to test a couple things, and I'm hopeful that there's some things in here that, everyone out there is listening can use in their practice.
Awesome. So today we're going to talk about the estate of Dolores Coda versus Providence Operations, Providence of Palos Heights. It was a case that you tried from the end of May, the beginning of June 2019 in Cook County with Judge Callahan, great judge. Judge. Right off the bat, this is a nursing home fall. You've got an 84-year-old decedent who falls and fractures her hip, subsequently declines. You said she ultimately passed away later from what appears to be complications from Alzheimer's. Is that right?
That's right.
Okay. How did you file the case to begin with then? If you have a client like that who subsequently passes away, removed from the incident that caused her decline?
Yeah, there's a couple of, strategic considerations that we needed to make when it came to how to present this case for trial. I got involved in the case kind of late in the game. We were finishing up doctor depositions when I got involved in the case. So all the fact discovery had been done. All the nurses and CNAs had been deposed. And, it was kind of time to retain our experts, figure out what kind of experts we were going to have, and figure out how to shape their testimony, present our case in the best light. And one of the things we decided to do was that we did not want to pursue a wrongful death case. Because, the death was 3 years removed from the incident itself. So we kind of, the link between the fall, the fracture, and then the death, there's a lot of there's a big time gap there. It would have been kind of tenuous. It would have been something that I thought maybe the defense would poke at. And, we talked about credibility before. Once you lose it, it's gone. So we didn't want to pursue that route. And in addition, the defense had indicated that if we were going to pursue a wrongful death case, they would hire a medical expert. They didn't hire a medical expert in this case, and we thought that the benefit of us having a medical expert and them not having one outweighed any potential benefits that a wrongful death claim would have.
So you said it earlier, and it's true. Most nursing home cases, I would venture to guess, the overwhelming amount of them do not get tried. And you don't see a lot of nursing home verdicts in Illinois with regularity. I mean, there are certainly some, and there's a fair amount of them, that there's not as many verdicts as there are cases by any means. Did you try to get this case resolved? What happened?
Yeah, absolutely. I mean, shortly after completing the F2 doctors' depositions, we actually sat down and mediated the case. And the mediation, ideally mediations bring the parties together, but every once in a while you get that mediation where the whole thing just goes sideways and the parties are in fact, solidified in their positions and they're farther apart than they were before the mediation even started. And unfortunately, that's what happened here. There was what I presume to be miscommunications between the two sides. It went nowhere, and it also kind of ceased the settlement talk. So we basically went from mediation through experts and through trial without any real settlement discussions, which again is very unusual, especially in a case like this. Nursing home case in the state of Illinois, as we talked about before, if you win a trial, you get fees and costs in addition to whatever the verdict is. So there's a lot of risk on the defense side, and there are a lot of reasons to want to talk about resolving the case. And, for whatever reason, that didn't really happen here.
So you have a mediation that goes south. You then have to go get experts, or at least start working full time with your experts. Who were your experts? Why did you like them? Why did you pick them?
Well, we ended up going with experience. Dr. Goldberg, who was our medical expert, is someone I've worked with several times in the past. He was a medical director at numerous nursing homes in South Florida for decades. He knows the medicine cold. He's a great expert. He's a very skilled testifier, and I've always enjoyed working with him. And I was confident, and I was also confident this case would settle. I told him, I said, Doc, there's no way this case is going to trial. So, don't worry about it. If you can help us out, that would be great. And sure enough, 6 months later, I'm calling him and, arranging his flight to come into Chicago to testify. And then Carol White also, she is a legal nurse consultant. She has nursing home experience as well. I like that she has the firsthand direct patient care experience that you need, in addition to kind of understanding her role, as a nursing expert and testifying, because it's not an easy thing. And there's only, you have to have a certain personality type to want to be a medical legal testifying expert. It's not for everybody. You meet 9 out of 10 doctors and 9 out of 10 nurses want nothing to do with this unless they have to. So it's, it takes a certain personality type. Some people really are good at it. They enjoy it. It's a competition in a way, where they're putting their side against the other. And, we had 2 really good experts who were tremendous for us at trial.
Even if you find a doctor who likes to do it, that doesn't necessarily mean they're good at it. So it's good to hear that you found 2 that were good patient advocates, good advocates for the plaintiff, which I think is something that is becoming harder to find. They, on the other hand, they had an expert who was also a nurse, but they did not have a doctor. Why not? And how did their nurse handle the entire burden?
I mean, it was an interesting strategic decision on their part. Like I said before, they indicated to us that they were not planning on having a medical expert if we didn't claim wrongful death. They were going to fight the case on standard of care, and that's why they went with this expert. After having reviewed her report, we decided not to take her deposition. In Illinois, we have these expert disclosures, and in a deposition, you can expound upon your expert disclosures. You can disclose previously undisclosed opinions in the context of a deposition. Having reviewed her report, having reviewed her disclosure, we were comfortable with the opinion she was offering. We were comfortable we would be able to cross-examine her and overcome her at trial. So as a strategic decision, we decided not to take her deposition. I know some attorneys take depositions of experts as a matter of course, In my opinion, it's a case-by-case basis. Depends on the expert, depends on their disclosure. It also depends if there are enough depositions of them out there, among the trial lawyers, where if you want impeachment testimony, you can get it. And based on all those factors, we decided that we didn't need to take her deposition, and we were more than comfortable with them not having a medical expert.
I think it's a great strategic choice. More and more, I'm finding that some defense lawyers really sort of half-ass their way through the disclosures because they have an expectation that we're going to take these depositions. And when I see a disclosure that someone has clearly not put a whole lot of effort into, you're stuck. I'm not going to depose your expert. I'm not going to give you an opportunity. I agree with you. It is a case by case, and it really comes down to how hardworking is your opponent and how savvy is their expert, I think, as to whether or not you want to depose them. And I think that is a great strategic choice.
Right. In this case, I'm not even saying their expert disclosure was deficient. We just felt comfortable enough with its contents that we were going to be able to overcome in a trial. But yes, I have experienced that exact same thing with other defense attorneys where their disclosures are general, they're not specific, they're lacking in detail. And it's a really, a good strategic decision. I mean, to the point where you even have defense attorneys trying to depose their own experts, which I've seen a couple times, and there's no rule in Illinois against it. So certain judges will allow it, but with the caveat that you can't elicit new opinions. All you can do is kind of expound upon the bases for the opinions that you've already disclosed. So it seems like, kind of a pointless exercise, but when you decide that you're not going to depose an expert, a lot of alarms start going off, back at the office, and then they realize, maybe I didn't include this. Maybe I need to clarify this, so it's more and more, like you said, there's not a need to take expert depositions. You have their disclosures, you have their report. I mean, how often are you really going to get them to flip at a dep? Probably not much. You're just going to attack the bases for their opinions, which you can do a trial anyway. So, based on all those things, we felt like it was the right call.
Sometimes you don't want to show your cards. You show your cross before trial. The other thing that I've seen, I don't want to get on a tangent about experts because we could probably talk about that all day long, but the other thing that I've seen is people taking depositions simply just to lock up the expert's opinion so they can't expound upon their opinions, which is just another thing to keep in the back of your head as a strategic choice as you're working with or considering deposing experts. So you get through experts, you've got two solid experts that you like, you've got a defense report that you think you can work with that gives you a lot of meat on the bone. What are you worried about as you're approaching trial? What are your red flags?
To be honest, my biggest surprise was that they didn't admit liability. I think that is one of the most powerful tools for the defense. Especially in a nursing home situation, 9 times out of 10 in a nursing home case, all of the plaintiff's good facts are liability facts. And this was one of those cases, in my opinion. We had what I thought was a strong, liability case that they weren't going to be able to overcome. And if they admit liability, and she was deceased, so there wasn't even an opportunity for punitive damages or aggravated liability or anything like that. So I thought from a strategic standpoint, what made the most sense to me, putting myself in the defense shoes, would have been to admit liability and try the case on damages. Because, all of a sudden the spotlight gets shifted. It's no longer on the conduct of the defendant. Now it's on the health condition of the plaintiff. And as an 84-year-old, our client was in pretty good health, but there are always those comorbid conditions, those chronic conditions. She was in the nursing home for a reason. She had medical issues and physical issues that needed to be addressed. And, had they admitted liability, the focus probably would have been on those things, but they chose not to do that. They chose to contest it. And I felt like that was a major concern because, they could admit at any point during trial, and all of a sudden the focus completely shifts. The other thing I was really concerned about was them making a decent settlement offer, at the courthouse steps. And, we talked about that you can get fees and costs. I mean, there's an argument to be made if we got a verdict that was at or just above the settlement offer made before trial, there'd be an argument against, our fee petition at the end after we get a verdict. they try to reduce it substantially. And that didn't happen, thankfully. Again, like I said, the settlement talks kind of fell apart before then. So those are my two really major concerns, from a legal standpoint, walking into the courtroom.
Sure.
And there was one more thing. This is kind of interesting. It's a fall case when our client was being assisted. So it was witness. It was an assisted fall. The CNA that was actually assisting her during the time of the fall was never deposed. She was a former employee by the time suit was filed. She was no longer working. We couldn't find her. They couldn't find her. But she was listed as one of their witnesses that they would potentially call a trial in spite of all that. So, obviously you're concerned about, her just showing up, during the middle of the trial, saying some, giving some damaging testimony against your client. I thought that was kind of remote and that didn't end up happening, but that was in the back of the mind as well.
Yeah, you never know when you get those disclosures, those final disclosures before trial, and those witness lists are exchanged, and you see a name where you think, did not expect that name to be on the list. It does keep you up at night, that's for sure, especially when it's somebody that is an eyewitness to the fall because she is part and parcel with the cause of the fall in this case. So that would definitely keep me up at night. Beyond that, were there any other evidentiary issues as you're headed into jury selection that you felt needed to be addressed and buttoned up before you felt confident picking a jury?
Yeah, definitely. A couple of the issues we had to address, and this is an Illinois specific issue. Former employees of defendant, hospitals or nursing homes are not considered adverse witnesses. So this becomes a problem, especially in the nursing home industry where there's a lot of turnover. So a lot of times, everyone that you would want to call as a witness of the trial, by the time the trial rolls around 2, 3, 4 years after the incident, they've all left the facility. And now you want to, cross-examine them as adverse witnesses, and the court won't let you do it. So, we moved to have them treated as adverse witnesses, based on the case law and, the way that Illinois law is as it stands, which I don't agree with, but it is the way it is. They were not considered adverse witnesses, which is, it changes your strategy a little bit. It changes how you treat the witness. I understood why the judge ruled the way he did. I mean, the law is the way it is. Again, like I said before, I don't agree with it, but that was something we tried to overcome. We weren't able to. There was also the issue of, in Illinois, facilities are required to report fall incidences to the Department of Public Health. Anytime there's a fall and an injury, they have to send a report about what happened. And then the Department of Public Health either chooses to investigate the circumstances of the fall or not. And, that choice is totally at their discretion. And in this case, they didn't investigate the circumstances of our fall for one reason or another. And what we moved to do was to bar any mention of the whole reporting process because it didn't have any evidence on any of the proofs in this case, and it was unduly prejudicial, and the judge ultimately agreed with that. And I'm thankful for that because, it could create all kinds of confusion in the jury's mind about, why didn't they? If this was such an egregious breach of the standard of care, why would they not investigate this? And that you kind of go down a rabbit hole about, the IDPH and all this other stuff that really doesn't matter. But it could certainly confuse. And I was glad that the judge had the foresight enough to bar that. And then we talked about this actually in one of our more recent episodes. I ended up moving to admit OBRA and the Illinois laws applicable to nursing homes as evidence of the standard of care. OBRA is a federal law that regulates nursing homes. In order to participate in Medicare, you have to be in compliance with OBRA. There are many experts who will testify that OBRA sets forth minimums of standards of care that all nursing homes need to adhere to. And then Illinois has their own specific laws. There's parts of the Illinois Administrative Code. Illinois has the Nursing Home Care Act that governs nursing homes, articulates resident rights and responsibilities, sets forth requirements. And we moved to admit all of those into evidence as evidence of the standard of care, and the judge allowed us to do that. So again, using motions in limine before trial, both as a sword and a shield to get what you want into evidence and exclude what you don't want out of evidence.
It's a good way to do it. And also, when you have those issues that are rabbit holes, it's very easy for any juror, I think even a lawyer who would be on a jury, to get sidetracked with ancillary facts because they can be interesting and they can be, sort of the aha TV lawyering kind of feel to them. So it's good to be using the sword as much as the shield when you're dealing with those pretrial issues. But once you get past them, in my opinion, the fun stuff really starts. Motions in limine, drafting motions, writing, anyone can attest is not my forte. It's the hardest part of the practice for me. But jury selection for most people is not their most fun thing. I love jury selection. How did you start off? What techniques did you use? What did you find that worked really well as you're picking a jury in Cook County?
We had a very long and drawn out jury selection process for a bunch of reasons. It took more than a day, if I recall correctly, to get 12 and 2 alternates. And the judge was great. He let us talk. He let us ask questions. At some point, after like the second or third panel, he was, counsel, they've heard all these questions. They understand they've been in the room this whole time. You don't need to keep re-asking them. But he kind of let us explore all the areas we wanted to explore. We wanted to talk about, their healthcare experiences, their experiences with, similar type injuries, any understanding they have about nursing homes, how they operate. Interestingly enough, we ended up having a more than, I'd say, a proportionate percentage of healthcare workers on the jury. Between the 14, the 12 and the 2 alternates, we had 2 nurses, a therapist, and I think we had another one who was in school for some advanced healthcare degree. So we had a lot of healthcare professionals and soon-to-be professionals on the jury. And, a lot of, the general wisdom among, plaintiffs' attorneys might be to get those people off. They know too much. They're going to protect their own. And in our case, we had really great, and I understand why they would think that way. But in my opinion, if you have a good meritorious case and you have clear violations of standard of care, these people are going to end up going to bat for you. And when we talked to them after the trial was all said and done, the therapist in the particular said, I never forget my falls. When people fall, it stays with me. I do everything I can to learn why it happened so that it never happens again, because that stays with you. You don't just forget about something like that. And I think that sentiment kind of resonated throughout the nurses and other healthcare people. And I think they ended up being, I assume, again, we're not in the room, but some of the most, some of the jurors that we really got on our side and really went to bat for our client.
Yeah, that's great. Sometimes you just have to not be afraid of those experts on your panel, because if you have the case like you had here and you can show them, they will do the right thing. Jurors want to do the right thing. And I think a lot of plaintiffs' lawyers are scared. Oh, they know too much, or they'll protect their own. That's especially common in med mal cases, and I'm sure in nursing home cases. But there are exceptions to every rule, right? And if you find good people who can do the right thing through jury selection, that can be a very powerful tool, I'm sure. Once this day and a half is over, you finally get a panel. You got your 12 and 2 alternates. Well, before I start, what did your panel look like? Was it, older, younger, pretty diverse, pretty plain? What do you think?
I would say it tended towards being younger and more diverse. And, some of it's just who you get that day, but it turned out for us in this case that those jurors ended up, responding to the questions that we were asking in a more positive way. They were coming into it with, less preconceptions than some of maybe the older jurors that were on the veneer. And our jury, while there certainly were older people on it, I would say on average it was younger, and we had a nice mix of people from all different backgrounds. It was a really kind of interesting group of people. And they all seemed to get on well together. Like I found out, I got to tell you, they talked with us for, I'd say an hour, maybe a little over an hour after the trial was over. And it was invaluable. It was absolutely invaluable hearing them, want to talk to us, sharing their opinion, sharing, what made a difference to them. And we sometimes you get lucky. Sometimes you do, sometimes you don't. And we happen to have a great group that day.
It's always better to be lucky than good, right?
Every time.
Every time. I'm with you. I had a really bad loss at trial 3 years ago, and none of the jurors spoke to us. They were given the opportunity to, and it's just heads down, walk out the room, don't want to talk. And then I had a trial last November, the last trial I tried before the pandemic that we won, and the same deal. They talked to us for an hour. The foreman invited me out for a beer afterwards. I mean, it was incredible. And you learn so much about how they saw the case and what you could do better or what you could have done differently, which is incredibly invaluable. So
speaking of the foreman, we had an interesting experience with the person who turned out to be our foreman. About midway through the trial, it wasn't that long. It was probably 5-6 days of trial. About day 2 or 3, she comes and she tells the judge that she's sick. She ended up, I think she vomited at some point during the day. And she said, no, it's food poisoning. And, we offered her the opportunity to leave. We don't want to hold her there. Although, we would have preferred her to stay, obviously. But at some point, you're not feeling well. You need to go. And she said, no. Like, she committed to the process. She wants to be there. She wants to see this thing through. And she ended up being the foreman. And I am so glad that she stayed because, when she stood up as the foreman, she was one of those jurors. I saw some signs throughout the trial, that in my opinion, I thought she was going to be, on our side at the end of the day. And when she stood up, first of all, I was like, well, thankfully we didn't let her go. I mean, that would have been a problem. But, you don't know what she's going to say. When she stands up. And I thought if we lost her, then we're not doing our jobs. So thankfully it all worked out that time.
The most nerve-wracking, 60 seconds from when the jury hands it over to the judge and then gets it back and you find out how everything went down. It is a nerve-wracking, your whole life flashes before your eyes kind of moment, right?
Yes, it does.
But before you can get to the end, we got to start at the beginning. You're stepping up to the plate for opening statement. How do you tell this story in a way that keeps the jury interested from the get-go? Because you have to have them, in my opinion, you have to have them captivated through jury selection and opening statement for them to care at all about everything that comes next.
Right. And looking back, on my performance doing opening, I looked back, the substance was good. What I said was good. I liked the way I sequenced it. I thought it all made sense. I thought it made, a relatively interesting opening. But the style in which I gave the opening and the energy which I gave to the opening was awful. I was not giving it the energy that it needed that day. I remember sitting down feeling like I did the job, I did the work, but I was not happy with the way that I delivered it. But as far as the substance went, I spent a lot of time educating about the role of the nursing home, about what it is, about what it does, about the different jobs within the nursing home and how it all works together, especially when it comes to the issue of patient safety. Because our client, she's elderly, she's a fall risk. And again, most of the patients in the nursing home are. So this isn't a unique situation to her. This is something that they have to deal with every day. And there are systems in place to make sure that people stay safe within the nursing home despite these obvious and known risks. And then, I talked about her story, her medical history. And our negligence theory was about as simple as it gets. She had a plan of care to keep her safe. And that plan of care included when she needed to get up to ambulate, she needed to use a wheelchair, and she needed limited assistance with that. Meaning she could wheel herself around, but if she was going to go a distance, she needed someone to help her. But the wheelchair was a non-optional part of all that. And, it's clear, it's black and white. It was in her chart. It was in effect on the date of the fall. From our perspective, this is about as simple as it gets. And then when it comes to the circumstances of the fall, there were 3 different versions. There was one that was documented, a different one in the investigation, and then a third one that was told to the director of nursing after the fact. And the one commonality between all of them was they didn't use the wheelchair. So, one was, she had a gait belt on and the walker in front of her, and they're assisting her that way. Another one that just the gait belt. And then a third, the gait belt was on, but it wasn't being used. They were kind of holding, the CNA was walking backwards, holding her hands, assisting her from the bed to the toilet when the fall occurred. So from our perspective, it didn't really matter because all of them are problematic. None of them meet what this woman's needs were. So that was, I focused a lot on that. There was also an issue of them failing to recognize the injury after her fall, which is a nice, way to hammer home the fact that there are systemic issues at this facility. It's not just this one nurse or this one CNA who's not doing their job. It's multiple people who are responsible for her, who are all not really being observant, who all aren't caring about what their job duties and responsibilities are. And then went through her damages. She fell, she broke her hip, she had the corrective surgery, she had the rehab, and then, she never really got better. That kind of precipitated a decline in her condition, that led her ultimately to get moved home, then put on hospice, and then the decline from there. And then you got to address the defenses, because you can't, there's 2 sides to every story. And, believe it or not, you may not agree with the defense's side, but they have one and it needs to be addressed. So it was more about, that they met the standard of care, that some of those versions were appropriate for her, despite what the client care guide said, about the fall being unpreventable, or her being, her behavior being a contributing factor towards the fall. And then the argument for damages that the decline was unavoidable because she had progressive dementia, it's a disease that gets worse over time, not better, all those things. So I tried to address all of those during the opening. Like I said, I want to redo. I think I could have done better, but I'm not going to argue with the results. So
I understand. I never like reading my transcripts after the fact. It's never a pleasant experience, but it sounds like you covered the harms and the losses really well and did something that I absolutely love, which is you're right. You have to address the defenses of the case, but it benefits you. Like, don't be afraid of them. Tackle them head on, because once the jury hears them and you get an opportunity, even in opening, even though it's not argument, to somewhat discredit them or frame them in a way that makes it sound like they're preposterous or sound like they're just flat out wrong. When the defense attorney gets up to give his or her opening statement, they're going to be in a bind because the jury is going to already be a little bit distrustful of what they say and is already going to have heard their defenses. And I don't know that they're necessarily going to find them persuasive at that point. So I really like that as a substantive way to handle it. That's really, really smart.
Right. In addition, with nursing home cases in particular, I find that it is absolutely essential to educate about what the nursing home is and what they do, because there's a lot of misconceptions out there about what is required of nursing homes. Some people think they're more like hospitals. Some people think they're more like, an assisted living type facility that provides minimal services. So it's really important to kind of clearly articulate what is expected of the nursing home and the ways in which they failed to meet those expectations. And again, do it before the defense gets up and tries to, articulate their version of the story. So hopefully by the time they at least stand up to do their opening, they have a clear frame, about what is expected. And that whole educational process, in my mind, reinforced by your experts, I feel like it really, in this case in particular, really drove home the verdict and drove home the liability aspect of the case.
And so you've got all the story out. You got to prove it now. You've told the jury what the evidence is going to be. Now you got to actually show them the evidence. Walk me through some of the highlights of the trial. Give me sort of the Sports Center top plays version of how you presented witnesses and evidence.
Yeah, the highlight for me was the client's husband, 90 years old, testified in the case. What a guy.
That's
just
awesome.
Amazing.
I love it.
The greatest. He said, I mean, almost didn't matter what he said. They've been married for like 60 years. He clearly loved her as much as anybody could love anybody else. And just watching her decline in such a way firsthand, him becoming, not only a husband, but, her caregiver at his age, it was a sad thing for him. And he could not have given a better testimony. We had him up there for 15 minutes, 20 minutes, just to give his 2 cents, and he's 90 years old. The fact that he came to trial is unbelievable.
Hey.
But he was just a great guy, one of a kind, cut from a different cloth. They don't make him like that anymore. He was tremendous. The other really kind of highlight testimony for me was the director of nursing kind of gave us liability on the stand. She admitted that none of the versions complied with the care guide, and that this whole walking backwards, holding her hands maneuver was improper. And they shouldn't be relying on her to bear her own weight and, do that under the circumstances. And, it was, as a visual, Mike Satina, the partner of my firm, and I, who were trying the case, we actually recreated the assistance level for the jury. So Mike and I were holding hands and walking backwards, and, I got a gate belt on, and it showed kind of the absurdity of the situation. And it really drove home, what are these people thinking? Why did they think this was okay? This is nowhere to be found anywhere as an appropriate method of transfer for her. The CNA just kind of went rogue. So it really kind of drove that home. And then, their defense nursing expert came in and tried to, clean it all up and say everything was fine. And Mike ended up doing it again. He borrowed our elderly 90-year-old client's walker and walked forward with the hands outstretched with the gate belt on, because they're saying the walker and the gate belt were there. But if they're holding hands, neither of them are being used appropriately.
Right.
So it's like, what's the point of a tool if you don't use it? And that became kind of a theme at closing. They're trying to cover themselves by saying the tools were there, but you're not using them. So it doesn't
recreating
matter.
Recreating that is a really great idea. It's a really great way to illustrate to the jury. I've seen that done in a lot of trials very effectively. It sounds like obviously this was a very effective use of the recreation, because you're able to illustrate the violations of the standard of care right in front of their eyes.
Yeah, it really did. And I felt like, that really kind of turned the tide. When you have the defense nursing expert disagreeing with the director of nursing of the facility they're supposedly advocating for, it's the case, the liability aspect is done at that point.
So beyond basically destroying their expert with their own director of nursing, any other highlights from the presentation of evidence that you thought really drove home the liability points or even the damages points that got you to this substantial verdict?
Sure. There was a hearsay issue because obviously the CNA, as we discussed, was not testifying at the trial. So there were some issues where she supposedly told the director of nursing a version of the events. We objected to it as hearsay. And, it was clear that the defense was relying on this evidence as a major part of their liability case. And, it's basically textbook hearsay. And the judge, held firm. The defense was pretty adamant, that this would be highly prejudicial to them to disallow this evidence, that, this had been relied upon in other areas of the case. But allowing that testimony in itself, the judge held firm. prevented them from substantiating some of their theories. And that kind of really, put a nice little bow on liability for us. And then when it came to damages, Dr. Goldberg, he linked it all together. I talked with Pat Salvi, several episodes ago about having those nice little phrases that the juries can kind of take back to the room with them. And the one that he came up with was, our client would have these incidents, they would be some setbacks, but there'd always be a bounce back. And that was kind of her pattern. She would improve, there'd be a setback, then there'd be a bounce back. Then something else would happen, setback, bounce back. But from this fracture, this fallen fracture, there was a setback, but there was no bounce back. It kind of precipitated this whole downward trajectory. And, it kind of really drove home the damages aspect of the case, because her condition before that, it's not like nothing happened, but she was able to recover. She had that vitality. She had that strength. But at the end of the day, a person can only take so much. And this ended up kind of overwhelming her and pushing her, on that downward trajectory.
I like that as a theme. Themes are very, very important. It's something that Pat Salvi and his firm does very well. They frame cases really well. They create themes that are really smart, that stick in a jury's head, because we have to understand these jurors are not trained in what we're doing. And then they have to distill all this information down to whatever form they can apply to the jury instructions while they're deliberating. And they're not going to remember every single detail that we put out in evidence. They're just not. As much as we wish they would. And they're going to take notes and they're going to do a good job, but they're not going to remember every detail, just like we might not remember every detail. So themes like that are really, really important. How did you carry that evidence and those themes into the close to really drive it home before the case goes to the jury?
Yeah, so when it comes to closing, looking back on it, I'm again, grading myself, always being my biggest critic. Better style, okay on substance, but it got the job done. I tried to keep it simple, try to keep it direct, and really hammer home our case, as well as, kind of give the defense nothing to talk about. That was kind of my main goal going up there was, our case is pretty simple. We've been there for 5-6 days, but at the end of the day, this is a simple case. That's obviously good for the plaintiff. The plaintiff usually wins, the A+B=C cases. And that's what, in my mind, I felt like this was. They didn't follow the plan of care, and that failure led to the harm. I talked about, the whole broken promises theme. When you admit someone to a facility, it's not a decision that's taken lightly. You end up, handing over care of a loved one to a nursing home staff. You're placing your trust in their hands, and they took that trust and broke it. They didn't know and didn't take steps to know their patient, didn't know what she needed to keep her safe. And because of that, she ended up having this injury, and that kind of sent her on this downward spiral like we talked about. And then after that, after kind of setting out, a pretty clear vision of what the case is about, I just kind of went out and tried to gut their defenses as best I could. There was this during the hand holding process, like I discussed, there was an indication that she took her hands away, and I talked about that and said they shouldn't be relying on the hands to support anyway. That's not what her care plan requires. That's not what reasonably careful nurses or CNAs do. They understand their patient's needs and they act accordingly. And then I had to address kind of the argument platitudes that the defense put forth. Falls can happen without negligence. Yes, in a vacuum, that's true. But in this case, it's meaningless. And what they're trying to do is have you ignore the evidence in the case and just focus on this meaningless platitude. That has nothing to do with anything that occurred in the case. It's not specific, and you shouldn't consider it. They also talked about the fall being unpreventable. And that's when I went into a decision tree. You've seen those where you talk about all of the decisions that someone makes within a matter of seconds that leads to an ultimate injury. Obviously car crash cases, that happens a lot. I think it's definitely applicable in fall cases. And I went through like 5, 6, 7, 8 decisions that the CNA made in the moments leading up to the fall that ultimately led to it. Had they made better choices, this could have been prevented. And, ultimately landing on that this fall was a product of poor choices of the CNA, not following the care plan, not doing what she was supposed to do. And I that's one of my favorite things to do. I find it's a really effective argument in closing, because a lot of times the defense tries to land on accidents happen. This was an accident, but it's not. If you really think about it, if you really turn your brain on and analyze things critically, this is a product of choices. And the choices that they made were bad. And had they made better choices, this wouldn't have happened at all.
Yeah, that's great. You have to be able to reframe their defenses and use them against them. And that's an awesome, awesome way to do it. How did you use the jury instructions, if you did, in closing? Because we have some very good nursing home jury instructions in Illinois that I think are very helpful to plaintiffs' lawyers in particular.
Yeah, we do. The nursing home instructions in Illinois are very specific, and I tried to frame a lot of my questions and a lot of the testimony to fit exactly with the language of the instruction about neglect in particular. And, but for me, the biggest issue was proximate cause and the damages. Again, I thought by the end of the trial, I thought the liability case was pretty solid. I wasn't really focused on that. I was more focused on proximate cause and damages. I was more thinking about them just kind of writing off her decline to Alzheimer's, to age, and just, kind of not giving her the damages that she deserved as a result of the harm. And what we ended up doing, I went through the proximate cause instruction. We got the long form, argued for it, and got it. And then what I ended up doing is using a visual, which I love, which I stole from Ed Walsh, one of the partners over here. I saw him use it at trial. I thought it was brilliant. And it's a circle of causation. It's literally a circle that I put up and showed to the jury. And within the circle were all the things that led to her decline. The Alzheimer's, prior injuries, prior medical conditions. And I put, the fall and fracture right in there in the middle. And I said, what you need to determine is that this was a cause or contributing factor to her decline and death. It doesn't need to be the only one, but it needs to be in there. If you think it fits there, then you need to award full damages for the harm that it caused. And at this point, we had unrefuted testimony from Dr. Goldberg, who said exactly that. And so it's almost like they had no choice, given the circumstances. But that circle of causation thing, it's simple, it's brilliant, it's effective. I recommend that you use it because it really, and one of the things when we talked to the jury afterwards, they said, I was really having a hard time with that proximate cause issue. And that circle of causation, it really hammered it home for me. It made it very digestible for people. So I can't recommend it enough. And I really think it helped get us, the damages award that our client deserved.
That's a genius idea. I really like that. That's especially, again, anything you can use to illustrate to the jury complex terms in simple form. That's just awesome.
Yeah.
So the verdict.
I'm sorry.
No, go ahead.
The other thing that jury instruction issue that was interesting, and I'm not sure what I would do again. We ended up using the professional responsibility instruction about the conduct of the CNA. We ended up having, what a reasonably careful CNA would do under the same or similar circumstances, as opposed to an ordinary care type instruction. And I was going back and forth about it the whole time. And because CNAs, they're not licensed professionals. They're not licensed by the state of Illinois. It's just a certificate. So I wasn't sure whether or not it was applicable or whether it was a good idea to kind of hold them, elevate their profession up to something that, it may not be. But at the end, I decided that I thought it was more appropriate because of the level of responsibilities that CNAs have in nursing homes for patient care and patient safety is astounding to those who don't understand how nursing homes work. And I thought that raising their level of conduct up to that of a licensed professional, at least as for a jury instruction, made a lot of sense because, the ordinary care instruction doesn't really take into account what a professional, someone doing their job knew or should have known. And in this case, there was plenty of evidence, plenty of testimony that had the CNA be doing their job, as a reasonably careful CNA, they knew or should have known that this transfer was inappropriate.
So how did the verdict shake out?
So we asked for, the past medicals were $63,000. That's the surgery, and that's basically it. We didn't, put into evidence any additional nursing home care. She was at nursing home before, she was at nursing home after. And then outside of that, it was all non-economic. It was pain and suffering, loss of a normal life, and then a loss of consortium claim for the husband. And what I ended up doing is, I gave a couple ranges on pain and suffering and loss of a normal life. What I like to do is I don't like to put the totals on the form. I just like to itemize each element of damage and just say, think about it, talk about it, and it adds up to what it adds up to. Don't worry about this number. Don't worry about these individual elements of damage, and then whatever it adds up to, that's the verdict. Don't work backwards. Don't start at the bottom and then figure it out from there. And so we ended up asking, the range was like 600 and something thousand to 700 and something thousand. And they gave us, pretty close to the bottom of our ask, which was, I thought great. And I thought, really reflected well on us, proving our damages case and arguing for it effectively.
Did you think, was there a consideration about just waiving the meds, not bringing them in? There's a lot of talk about how, smaller meds, and $63,000 is not a small amount of money, but it is when you're asking for $700,000 in terms of a verdict, and it can anchor you down. Did that cross your mind, or how'd you handle that?
It did, but in this case, we thought that the evidence was such that we weren't going to be anchored. It's a case by case situation. I thought, Pat in his episode talked about, he got a $3 million verdict on a case with $40,000 in medical. I mean, this is not that case. I didn't think that the proportions were so out of whack that, we were going to be anchored by that. And like I said, we had uncontested medical testimony from Dr. Goldberg that I thought really brought it home. And, given what we had, and there wasn't much contesting the past medical, it wasn't really a fight. So to me, it seemed like it would have been, leaving a line item off the verdict form had we just waived it.
That makes sense. So the case goes to the jury. They go back to deliberate. And now comes the worst part of the trial, where you sit and you wait and you pace and you try to eat, but you can't. And you freak out inside and out. There's a lot of superstition, and there's a lot of theories about jury comes back quickly. It's a defense verdict. If they take longer to deliberate, it's because they're trying to work out a complicated issue, or they're having a debate about how much money to give you or whatever else. What happened here?
So in this case, Mike and I go back to our Chicago office. It's right across the street from the courthouse. It's about lunchtime, but we just, we sit around, you snack on some pretzels, and we just sit by the phone. And, 30, 45 minutes later, he says, you know what, I don't think this would be a bad case if it came back quick. This might be one of the ones where it might be okay. No sooner had he finished uttering those words, the phone rings. It's the clerk. They have a verdict. We need to get back to the courthouse right now. And the jury's only been out, like I said, like an hour, give or take. And so I am just stressed out. I'm pacing the hallways. I am not talking to anybody. I am just in my own head completely, because I'm thinking, the superstition is, or the common knowledge, and for good reason, is that quick verdicts are defense verdicts. And so I'm thinking we lost, and I can't figure out how. So I'm just beside myself. And we end up, I run into a friend of mine. I told him, the jury just came back, and told him to stick around. And he's like, I talked to him afterwards. He's like, I've never seen you like that. I'm usually a pretty even keeled. I was not even keeled. I was all over the place. So we sit down, the foreman reads the verdict. I'm just, elated. The client is extremely happy. It was a really nice moment. And, but I got to tell you, I thought we lost for sure. jury coming back that quick. I don't know how they could have done the math in that amount of time. But we talked to them afterwards. Like I said, they were very open. They basically said they went back in the room, they all sat down, and they did show of hands, on liability, who's for the plaintiff, and everyone put their hands up. So they spent the rest of the time talking about damages. They came to a decision, and then they ordered lunch, like any good jury will.
Yeah, smart jurors. If you're going to get a free lunch on the county, you get a free lunch on the county.
That's right.
Absolutely. Absolutely. So after the trial, you've got your verdict. The work's not done. We know when you have a verdict, you got to go protect the verdict and everything else. But with a nursing home case in Illinois, because the CARE Act is the way that it is, there's work to be done to get paid. Talk to me about your fee petition, the process, and how it went.
Sure. So, after the verdict all goes to the client. That's the client's verdict, which is great. It's the best thing about doing nursing home cases is all of that money goes to the client. So we needed to petition the court for our fees and costs because that's supposed to come from the defendant. And so, about a couple of weeks after the verdict, I file my fee petition. I cite to the act. I cite all the relevant case law, and I asked for. And it's another thing. You also need to choose how you're going to present your fee petition. And that is based on a lot of things. It's based on the verdict, and it's because you can either go with the lodestar calculation, which is, reasonable hourly rate times how many hours you worked, or you can ask for a contingency fee, 1/3 of the verdict, basically. So we ended up going with the contingency fee, basically because we had no choice. We didn't keep contemporaneous track of our time. We would have had to recreate timesheets whole cloth after the verdict, which the court would obviously frown upon. They would have been obviously just holes would have been poked through by the defense. It would have created a mess. So we decided in an effort to keep it clean, we would just do 1/3 of the verdict. And it was an interesting time in Illinois nursing home law because friend of the pod, Margaret Battersby Black's, $4+ million nursing home appeal had come down, but was yet to be published. They'd moved to publish it, and it was still in the unpublished phase. And I asked the court to take notice of the fact that the motion of publication had been granted, and the judge ended up continuing the case and the fee petition until after that case was formally published so he could rely upon it as case law, and then ultimately agreed that a 1/3 fee, was reasonable under the circumstances, and gave us, basically, I'd say 90% of the costs that we asked for and petitioned the court for. So it was a good result. It was a little bit, circuitous, but we ended up getting there. And it's really, but that I got to say, for people, and I know myself, I've been doing this all my nursing home cases, keep track of your time. I know we're not defense attorneys. We don't bill by the hour. It is worth it 100% to keep track of your time on a nursing home case, because the case law is such that as long as the fee is reasonable, that's what you get. It doesn't have to be in proportion to the verdict. There's an Illinois case where someone got a very, very small verdict. It was like $15,000, $20,000, but they took the case all the way to trial and petitioned the court for like $87,000 in attorney's fees and got it. So keep track of your time. It's worth it. It'll benefit you in the end. If I had been involved from the beginning, I might have, done that throughout the course of this case, but that was way gone by the time I got involved.
I agree. It's the one vestige of my days as a defense lawyer that I hold on to is any nursing home case that we handle in our office. I am religious about keeping track of time for that exact reason. Many of these don't get tried, but in the event that it does, you can't, recreate the wheel in that sense. You have to have been keeping track the entire time. So that's a great point. And again, another one I think we really need to keep in mind as we're litigating these cases. So fantastic. I mean, really cool to be able to talk to you about this tremendous verdict. Anything else that you took from the verdict or took from the trial that change the game a little bit for you in your practice, that you know you're going to try this or do that we haven't talked about?
I mean, as far as presenting my arguments and opening, I was very critical of myself. I stand by my criticism. I was not great. I tried to overdo it on substance. I tried to basically write it out, like commit it to memory or have it in front of me and just kind of present it that way. I need to allow myself the room to, be natural, to be, energetic and not be bound to words, because, as lawyers, words are always very important to us.
Right.
I always want to try to say the right thing. I don't want to overstate my case. I don't want to understate my case. I'm always trying to present things in the best way possible, but that can't always happen in trial. You need to be able to, you need to have enough confidence and enough, wherewithal to, understand what your case is about and just trust your gut instincts and go for it. And I think the jury end up responding to that energy almost as much as if you just read the perfect words off of a piece of paper. So that's kind of my big takeaway personally. Style wise, I mean, substantively, I mean, the damages case, I thought I ended up using some of the reptile methods for damages, about
Good
isolation, about dependency, and I kind of hammered those as themes to support our damages case. And I really thought that they really helped. I'm a big believer in kind of taking what works for you from all the different resources that we have out there. You and I have talked about different books that we like from different lawyers, Mitnick, Rowley, the reptile, all those things, take what works for you, take what feels natural for you and fits the case. And I thought, because that was my biggest concern, was arguing damages. And I thought those kind of reptilian principles and arguing those really kind of hammered home the point to the jury. And, with elderly people with nursing home cases, I feel like that's something, that really resonates with people, and something that I would certainly, there's something that I definitely thought worked.
Yeah. Two of the things you said are two things that I try to remind myself of often, is that every trial, win or lose, is an opportunity to get better at doing this. And especially if we win, it's easy to win a trial and think that you're awesome at this. And so to have the self-awareness to be able to go back to the transcripts and go back to what you did and figure out how you can get better is such a benefit to your clients going forward. It's such a huge and important thing. And the other thing that I have to remind myself of is, I want to be a trial lawyer like you or Pat Salvi or Nick Rowley or whomever, Jerry Spence, but I can only be me. And I have to be the best me I can be by using these techniques in the way that they work for me. And if I do it in an inauthentic way, jury's going to see right through it. They're not going to rely on me. I'm not going to have credibility because I'm trying to be something that I'm not. And so you're right. You have to figure out the right way that these puzzle pieces work for you, because they work if you make them work.
Right. And one other thing I wanted to touch on is that I know the jurors had no basis for comparison, really, because all of them, this was the first time on a jury. But the fact that defense counsel and us, we got along, there wasn't a lot of arguing, there wasn't a lot of objecting. Most of the business was handled behind closed doors and didn't take a long time. There weren't a lot of interruptions to the trial. We tried to keep things moving. I think that they really appreciated that. I know I appreciated it. The professionalism from defense counsel was incredible. That was one thing I came away from them personally, was, they truly respected the law, respected the process. And we, you end up reciprocating,
Right.
And when you create an environment where, we have a legitimate disagreement about what happened and the facts and the value, but it didn't become nasty, unprofessional, unnecessarily confrontational. And I know the judge really appreciated it, and I think the jury did too. And ultimately, I think that inures to our benefit to have as much of a smooth process of trial as possible. I mean, sometimes it can't be helped, but, I think it's to our benefit to try to foster that environment, to the extent possible, and make trials move faster, smoother, less interruptions. All that stuff I think is to our benefit and ultimately to our clients' benefit.
I agree. I agree. It's also a small community. It's a small legal community. There's 11 million people in Chicago, but it's a small legal community, and you can easily get a reputation for being disagreeable and a jerk and somebody who's not a professional, just because you're taking your adversarial process too far. It's an adversarial confrontational process. It's the way it's designed. It's the way it's set up. But you don't have to be a jerk about it. And I think that, to your point, if the jury sees that, they're going to blame everybody, but you're the only one that has a burden, and you're the only one that's asking for money. So at the end of the day, if they blame everyone, you lose. And if you can be the most professional person in the courtroom, even in the face of absolute jerks, which thankfully it sounds like you had some very good defense lawyers on the other side who were very professional. And, most of the time that's what we run into. And most of the time that's who we try to be as plaintiffs lawyers and when we're encountering defense lawyers. But there are jerks in our profession, like there are in every profession. And as long as you're just being the ultimate consummate professional, I think that the jury sees that and you'll win out in that sort of realm.
Absolutely. With that, I think we're going to wrap up for the week. We've kind of, this is a long one for us, John. We're well over an hour ago. But
it's always just good to hang out and talk, though.
Hey, I'm here. I'm here all afternoon. I cleared the afternoon for this, so hey,
same here.
We can do this for the next hour, as far as I'm concerned. But let's not do that. Let's end with a nice 30-second trial tip. Things we do to make our cases stronger and our trials better. John, what's yours for this week?
Good artists borrow, great artists steal. So a lot of the things that you talked about from your trial are things that I'm going to steal, but in particular, the proximate cause arguments that you talked about. That's gold. And if everybody listening to this does not use that, you're missing an opportunity to score points. That is an awesome tool that I'm going to use in every single trial going forward. And that's the thing that, sort of I was talking about with books and methods is you have to be fearless in your incorporation of other people's methods and other people's successes into your own attempts. And you have to do it in an authentic way. So don't hesitate to steal. If you find something good, steal it, run with it. How about you?
All right. So I'm moving away from the trial because, how do we settle cases these days from no trials? We mediate. I had 2 last week, and my takeaway from those 2, the similar circumstances between them, they were both, one was pre-suit, one we just filed suit. So early on in the process, and the important thing that I needed to do and that the mediators helped me with was do the math. Do the math for your clients. Make them understand, to focus on the bottom line of which is what happens after fees, costs, liens, other expenses, what the ultimate benefit is to them, versus, what the top number is. Because, as cases go on, expenses get more, sometimes fees can go up, things that you need to get a much better result at trial to get the same benefit that would you be if you settle for a slightly less today. And you need to do that math for the client. You need to explain it in those terms, in addition to, the weight, who knows when, especially in Cook County, who knows when we're going to be trying cases, explain the benefit, do the math, give them all the options. I mean, that's ultimately our job as counsel, is to help them make the best decision possible under the circumstances. And, if you got a case where the client's going to net the same at, they settle at 100,000 today as they would at 250, 2 years from now, you need to be able to do that math for them and explain it to them. So that's what I ended up doing for both those mediations. They both resolved. Clients, happy clients, happy clients, happy. I was going to say happy wife, but that we got to cut that. We got to cut that out. We got to cut that out of the thing. But ultimately, you do the math, you explain the options, and you give the clients the best information to make the best decision for them.
Definitely.
And that's our episode for today. Remember, you can follow us and send us comments, questions, episode ideas, or just troll us on Facebook, Instagram, and Twitter at On Trial Podcast. Please also rate us and leave your feedback on iTunes, wherever you download your podcasts. And until next time, we'll see you on trial.